members of the House. This amendment specifically pertains to the Civil Rights, the Iowa Civil Rights Commission, and its authority to conduct its business as spelled out in the Iowa Civil Rights Act. They're specifically empowered, the commission is specifically empowered to investigate, to hold hearings, all pertaining to holding Iowans accountable to our civil rights law. It's one thing when looking at boards and commissions to look at efficiencies, whether it's savings or a board isn't utilized. It's another thing to take away the fundamental nature of a board and commission. Before I finish my opening comments, I do want to quickly remind folks, and in some case just inform you, that the Iowa Civil Rights Commission was formed and created by the Iowa Civil Rights Act of 1965. And it says the commission was empowered to hold hearings and address complaints of unfair or discriminatory practices in public accommodations and employment at the time because of race, color, national origin, or religion. And dissatisfactory rulings could be challenged in the state's courts. The fundamental nature of that commission is to act, to conduct. This particular amendment removes the entire section related to the Civil Rights Code. And before I yield, I want to point out that, especially our attorneys in the room know that words matter and language matters. And right from the beginning in this bill, the definitions of the director, the power of the commission, and who has the ability to conduct that authority is changed right in the beginning of the definition of this particular section. Those are my opening comments, and I'd be glad to answer any questions.
Is there discussion? The chair recognizes Representative Bloomingdale.
I'd like to thank Representative Wilburn for bringing this amendment. I do believe that the commission will continue to hear cases and make decisions as they do right now. The director of the agency will now be in charge of her department and the 27 full-time employees instead of a volunteer board. But the volunteer board will continue to hear cases and make decisions on cases just as they do now. With that, I would ask the body to resist the amendment.
Seeing no further discussion, chair recognizes Representative Wilburn for closing remarks, Amendment H8328.
Mr. Speaker and Representative Bloomingdale, I disagree with the conclusions about whether or not words matter in this particular section of how you have of the bill, the original bill. On page 92, at the top it says, the agency does not include a member of the Iowa Civil Rights Commission. Throughout this section, it describes and ascribes the power that previously was with the commission to the agency. At the top of page 92, it says that the agency is a function of the office, including the director and the staff. It does not say, in fact, again, it specifically said, agency does not include a member of the commission. Throughout the section, again, it talks about the agency and the office. I also want to call your attention to one particular section. If the words don't matter and you're saying, Representative, that the board retains its function, then why on page 98, line 30, section 260, there's a new section that describes the powers and duties of the commission? If the powers and duties of the commission were not changed, what's the need for a new section? Also, on page 101, I believe line 91, it specifically says the director, it crosses out, it strikes out a section that says the director must have approval of a commissioner in order to do certain functions. There are over 50 times where the ability of the commission to establish rules is crossed out, it's stricken in the bill. And replaced with procedure. There is a difference. Words matter between a rule and a procedure. Currently, the board has the ability to set rules, obviously within the structure of the Iowa Civil Rights Law and the Americans with Disabilities Act, Section 504 of the Rehabilitation Act, and on other civil rights statutes. But procedures are guidance on what to do, how to do it, not the ability to set the rules. We've received a lot of correspondence from different civil rights organizations, NAACP, LULAC, concerned citizens, about them noticing the difference that words matter in this particular bill. It takes away the authority of the board and gives it to one person, the agency, which was defined as the director.